Good afternoon. My name is Ala McCoy. I am Director of Startup Support at the University of Maryland UM Ventures, and I would like to extend a warm welcome to all of you who joined us today for the next installment in Startup Fundamentals workshop series, both our live audience and those watching it on our Startup UMD YouTube channel. This workshop series is offered by UM Ventures and Maryland Technology Enterprise Institute at the University of Maryland. To all of you attending our live session right now, please feel free to submit questions using the Q&A function. You can find it at the bottom of your screen. As a reminder, we are recording this session and will be posted on YouTube. So if you would like to remain anonymous, you can do so by selecting the Submit Question Anonymously option. So now let's get to our topic of conversation today. Many founders don't think about intellectual property until an investor asks, a competitor copies, or a partnership stalls. Today, our speakers, Alfonso Chen, Kathleen Tierney, and Halima Ndai of Cahill, Gordon, and Reindel, will demystify patent and copyrights, what they protect, how they work, and how they fit into a startup strategy at different stages. And then at a later date, and I will post a registration link, they will also talk to us about trademarks and trade secrets, and other very important forms of intellectual property. So please, Alfonso, Kathleen, and Halima, the mic is yours. Please take the stage is yours, the mic is yours, and everyone, please submit your questions as we go.
All right. Well, thank you very much, Ala. I really appreciate the introduction. And thank you, everyone, for joining today. We're delighted to be here. We're very excited to be working with the University of Maryland and all of you. The great ecosystem that's been built up for innovation and entrepreneurship. One of the things that I want to make sure to tell you is that where we welcome questions at any time that you may have, but also understand that this is informational, this is educational, and not intended as legal advice. If you need legal advice, let's talk offline and we'll talk about that separately, and have that confidential, but this is really meant to be educational and start a conversation. Okay. So with that, I'm going to turn it over to my colleagues, and we'll start with my colleague Halima Ndai, and she's one of our lawyers in our DC office. So take it away, Halima.
Thank you so much, Alfonso. Hi, everyone. My screen should be coming up in just a second. You can see that okay, Alfonso? Just give me a thumbs up so I know everybody can see it.
Yes.
Awesome.
Want to full screen?
Yep. Weird. Okay. Do you see the next slide? Okay.
So we see not in the presentation format, but when you're looking at it and with like little slides.
Oh, technical difficulties right at the beginning. Oh, sorry.
No worries. There you go. Oh, no.
My sincere apologies, everybody.
No worries.
Think that should be fine. All right, so today we're going to be talking about patents, copyrights, and some costly mistakes. Obviously, some of the costly mistakes we'll be talking about is not everything. We can talk about some more offline. If you have any questions about some of those mistakes, we'll be happy to answer those too. But these are some that we highlighted and we've seen come across. So starting with patents, what is a patent? So a patent is generally like a grant from the government that allows you to exclude others from using, selling, or selling your invention. So it's not an affirmative right. It doesn't really necessarily say you get X, but it allows you to exclude others from practicing your invention without your authorization. Now, patent rights were actually authorized in the Constitution, and as some of you might know, the founders, some of them were inventors, like Franklin. You can Google some of their inventions and get a little bit of history
Okay.
on that.
So Halima, you're still on the introductory slide, so we can't see the following slides.
Interesting.
Paula, do you have our presentation? Perhaps
Yeah.
if you control it, we might be able to you share the screen, you may be able to show different screens.
I don't have your PowerPoint, but if you send it to me, I'll be happy to. I was just typing up that I can send it.
Yeah, let me send it to you real quick.
In the meantime, would you like to do an intro of everybody on the panel while we're doing this? And
Be happy to.
yeah.
So let me give you an introduction to myself. My name is Alfonso Chan, as I mentioned before, and I've been practicing for over 26 years, primarily in intellectual property, licensing, and litigation. And the other, I think, interesting aspect about my practice is that I focus primarily on universities. In fact, my first trial was involving a university patent, and since then, I've handled a lot of matters for many different schools, both large private schools like large public schools like University of Maryland, as well as private schools. And so we handle many different technology areas, from life sciences to engineering to physical sciences. And so again, we're very, very happy to go and to be here and to help begin the conversation with everyone here. So um, I believe, Kathleen, why don't you give an introduction to yourself while Helena's working through these technical issues?
Sure. Hi, everyone. I'm a litigation associate at Cahill, Gordon, and Reindel. I've worked on a variety of IP and patent litigation cases, specifically regarding universities and pharmaceutical cases as well. So excited to be here.
Ala, please let us know if the presentation came to you. And I'm sincerely sorry about the technical difficulties on my end.
I am downloading it right now. You can introduce yourself in the meantime.
Okay. Hi, everyone. I'm Halim Mandai. I'm a patent attorney. I've worked as a patent attorney since 2017. Mainly do patent litigations, but we work primarily with universities like yourselves and inventors and helping them basically understand what IP is, how their protections work, enforce their portfolios, understand their assets, and I'm very excited to be here today.
Right. Can you see the screen?
Yes.
Yes.
Yeah, in full slide format, correct?
Perfect.
All right. All right. Now let's go.
All right. So
Perfect.
this is what we're talking about, and basically how patents are authorized under the Constitution because of the founders' history on innovation and being inventors themselves. So the patent statute, which is Title 35 of the U.S. Code, essentially allows for patent protection, and basically all the avenues in terms of litigation rules and things like that would be in Title 37. If you can go to the next slide, please. So there's actually different kinds of patent. The one we commonly see and most people think about, especially when you're thinking about litigation, because that's really what comes up in news articles is patents that have been enforced on or in active litigation is the utility patents. And as you can see on this slide, these are roughly 90% of all issued patents, and they capture, they're intended to protect new and useful process, machine, manufacture, or composition of matter, and obviously new and useful improvements of those categories. So process, machine, and manufacture. And once you get a patent, the protection lasts for 20 years from the date of filing. So say you had your application put together today and you took it to your patent agent or patent attorney and they filed it today. So that clock will start running from the day you file with the patent office. And then on the side, you can see one of the earlier patents of what a utility patent really means is functionality, right? So some of us would never have thought of this in modern day, but obviously at that time, I thought it was pretty funny that they actually needed like the idea of being able to protect while eating or stuff like that was actually a patented invention. Obviously, that's not applicable in today's field, and you probably won't get a patent on that, but historical context. Next slide. The second type of patent is design patents, and really what this one covers is the look of the thing, like the look of the ornament, the look of the design, and the most common example is really the iPhone. When the iPhone first came out, like that design, that look was so unique to the iPhone even today that when you have two, Samsung versus iPhones sitting next to each other, you instinctively know that's an iPhone versus that's a Samsung phone. These ones last up to 15 years because of like what they protect in terms of like coverage is obviously a lot narrower than utility patents. So you could have a patent on the look of the iPhone, and then the functionalities and all the other features like the screen being able to like stop glares and things like that would fall under the previous category, which is what we talked about, which is the utility patents. And then next slide, we have the last group of patents. I actually have not seen this in practice. I know they exist, but this basically protects man-made essentially plants, like so plant protection for any or new discovered asexually reproducing plants for up to 20 years. Again, now with the cannabis things blowing up, essentially, that's one good example of like how man-made from natural resources essentially come up with the new things that were not naturally available. And that's the kind of plants that the plant patents protect. So someone put in the chat that University of New Hampshire is the proud home of original varieties of white pumpkins. How many of those are patented? I would not know off the top of my head, but we can Google and find out later. Excellent.
I do know that the University of Arkansas has those cotton candy grapes. They have plant patents on cotton candy grapes. So I don't know if you had those before. My wife likes cotton candy grapes. So
my kids are addicted to them.
For the gardeners or those who work with plants in their practice in terms of like agricultural inventions or agricultural fields, this will be also very relevant to them. Next slide, please. So now that we know the different kinds of patents, why do we have patents and why are they, what purpose do they actually serve? So we'll go into it a little bit more detail, but a patent essentially is a full-on disclosure. So when you come up with your invention, you have to write it out, and we'll walk through the different parts of an application. But basically, patents are an avenue for you to disclose your inventions such that, to foster and reward invention, but also so that the public can see what is patented and actually make use of it. So one is innovation. So we want you to be protected. We want you to actually keep making things. And that only comes from once the public has access to the information, right? So if you're in your own little solar isolate place, making your own inventions and never disclosing it, then we can never get any rewards from that as the general public because that information is just unique to you and not necessarily the everybody else. And then the last thing is we will go through the process of getting a patent, but because of how patent law works, there's strict requirements on what is actually patentable, and that is to ensure that you are not claiming to invent something that's already in the public domain. So once an invention is made, it's released to the public can continue to foster new innovations from what has already been disclosed and basically build upon the knowledge that came from your research, from your publications, from your invention. But the requirements ensure that you only get what you actually contributed to the public domain. Next slide, please.
There are a few questions about patents.
Oh, I'm
would you like
sorry.
to answer them now? So in the queue questions, so recently conducted a patent ability search. The probability of the invention being novel is good. Can you file PCT and USA patent applications at the same time?
Yes, I can I'll address that right now. It's a pretty specific issue, but so what happens under the Patent Cooperation Treaty is that you can use that PCT application in order to serve as your initial filing in many jurisdictions, including in the United States. And then after that, you can go and elect the countries that you want to have specific prosecution an application in. So, for example, you file a PCT application, and then after that, you can go and file, U.S. and Brazil and Europe and China. Let's say if those are the countries you want. So, at any rate, but continue on. That was just sort of a short answer to that.
Yeah, that person is ahead of us. Next slide, please. So the example we're going to go over today is obviously a U.S. patent. We're all U.S. patent attorneys here. Caveat that with, obviously, you can get patents in other foreign jurisdictions, which is what the PCT Alfonso was just mentioning. So different offices, so you would essentially be filing, say, if you're interested in getting patent protection in China, you would file one there. You'll file one in Mexico, depending on what your strategic interests are. So for our purposes right now, we're only looking at a US patent. So the cover will look this different, obviously, if you're looking at a Chinese patent versus a US patent. So the cover page, this is what we have on the screen right now. And basically, it's a snapshot of everything. It includes the patent number, the date it was actually issued, the inventors. So on the number that says up at the top, United States, and then Malone afterwards, like number 12, that's basically the first named inventor. So if you go down to the list of inventors, this one only had one. It's Joshua Malone, and usually like it'll be the United States patent number on the side, the first named inventor, the date of issued. It also has the abstract, which is the summary of the invention. So if you could boil down what your invention was, looking at the entire specification, looking at all the claims, what are you actually saying is your invention? And that's what the abstract is. Generally, it will also have one representative figure if there's figures in that patent. Most of the time there are. I've actually not seen one that didn't have a figure of some sort. Depending on what the invention is, obviously. And then other information, so like classifications and things like that, which are not really what we're gonna harp on too much. But basically, it gives you a snapshot on the patent, the title, who the inventors are, date of issue, description of what the invention is. Next page. So we just talked about that a little bit, the abstract. So usually it kind of mirrors a little bit what the claims are, language, when you pull up a patent, you will see, but similar to what the claims say, similar to what's different embodiments in the body of the patent, what's called the specification. So what the abstract really is just like I said, a brief description of what the invention discloses, and it's usually very high level because generally what you don't want to do is like make it really, really narrow, and then you look at the specification, and it's like the specification is way broader, the claims are way broader, so you're trying to capture it in totality. Next slide, please. So the cover page included the inventors, and we talked about the first named inventor being highlighted at the top. But the Patent Act actually says who an inventor can be. And in US patent law, inventors can only be a natural person. And this is relevant now in the AI world because you might be using AI to help you in some of your research. This has actually been litigated to figure out if AI can't be named on a patent. But the case law now and the law right now, the answer is no. So only the human running the AI would be considered the inventor. Next slide, please. So the specification is generally what the bulk of the patent is. So you look at the first page, you flip over, depending on what the invention is, it might have, a lot of figures, and then you get to the meat, which is the descriptions. And the descriptions also usually include a description of the figures. So if figure A, blah, 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 you would describe what actually discloses and how it functions, the various details that goes with it. So even though a picture is worth 1,000 words, you still have to put your 1,000 words on paper for a patent. And that's what the specification is. So it generally includes some background of what the art is, art being like the field of the invention, what is it that the problem that you were trying to solve, what are some of the other inventions out, or what has been previously done to solve this problem, and now like segueing into what is it that the invention now is going to solve in terms of like the problem you're trying to fix and how it moves your invention essentially brings forth something new. Next slide, please. Oh, sorry. So the biggest thing with the specification, and this we'll talk about a little bit more, is it needs to be detailed. And as much as you can say about every embodiment or every form of what your disclosure is, like it needs to be a full disclosure. And this goes back to what we talked about earlier, which is the purpose of the patents is you need to tell us enough so that if I took this paper and I read it, I, as someone skilled in the art, would be able to take your description and make the thing that you're telling me that you made. So it needs to be disclosure to that level. Next slide. And then at the end of every patent is what you would see is the list of the claims. So the claims are generally, when you think of a invention, when you think of patent litigation, like what the actual invention is, the scope of your invention is what is in those claims. And these are usually like numbered lists, depending on how many, it can be 5, it can be 10, it can be, but the way, at least in the US Patent Office works is, you can figure that out later with your patent prosecutioner. But like the more claims that you have, the higher the costs, just generally. But there's claim sets and cost varies based on, whether you have 50 versus whether you have 100 claims in that one patent. So the claims delineate what the metes and bounds of the invention actually is. It's what tells people the fence around your house. Like, this is the thing I made and anything inside it is mine. So once you trespass on this fence, now you've trespassed on my invention. And that's when, patent enforcement rights, that's where they begin, is the fence is the claims. So the last point on this is patent infringement lawsuit is brought on the basis that certain claims of a patent have been infringed. So when you're doing a patent litigation, usually what you're looking at, as I said previously, is the patent claims. So the patent claims says A, B, C, and we can go to the next slide as an example. And that tells you what the actual invention is. So this is how they're normally written. It can be a method claim, it can be an apparatus claim. Usually starts out something like an apparatus comprising this, or a method comprising then a list of steps or a list of components. So in this one, we're talking about an apparatus comprising a housing. Comprising usually in patent terms means it includes this, but it can include other things as well. A housing, a plurality of hollow tubes, Plurality is a term of art that patents generally include, and we like to use a lot, but it just means more than one, a few. A plurality of containers, a plurality of fasteners, wherein the apparatus is configured to fill the container substantially simultaneously with the fluid. So basically, this describes what the figure is. So it has A, B, C, D, and D can be this. That's essentially what this is saying. So if you were to take any claim, you should always be able to like break it down into the elements, which is what we call, the housing component in this example. The plurality of hollow tubes will be another element. So you would be mapping the apparatus that has feature A, feature B, feature C, feature D, and then the whole thing should be configured to do this functionality, which is the thing at the bottom that's highlighted in yellow. Next slide, please. So, as I said earlier, we're going to be talking specifically about the US patents. And in the US, when you're trying to file a patent office, who you file with is the US and Trademark Office. So I think this step maybe some of you might have done it already, but you come up with your invention, you do what's called an invention disclosure. If you're working with the university's tech transfer office, for example, that's what they ask you to bring in. You fill out what your description is, fill out, the dates that you came up with it, etc., like all the details that they require. Have you previously disclosed to this? If so, when was that date? And we'll talk about why that's critical. Um, you know, any publications that you've made, as much details about what your invention is. And that's essentially what you would turn over to your tech transfer office or your patent prosecutor. And here, prosecutor actually means the people who help you get the patent, not like the rest of the legal profession where prosecutor actually means the attorney prosecuting you in court. But so the application is submitted to the US Patent Office. The US Patent Office now looks at the disclosure and who exactly does the examining. They're called examiners. They can be attorneys or not attorneys generally. So they will look at everything, do what's called a prior art search or search to see, has this been previously disclosed, or are there other inventions that cover the same thing? Is your thing actually new? And we will look at some of the stuff on the next slide. Some of the stuff that they consider to see, does this invention actually warrant getting a patent? And the four things they look at is patentable subject matter, which is 101. 101 just basically means the things that you can actually patent. And we talked about that earlier, process, machine, and now I'm spacing on the third. But the things that are not patentable is laws of nature, natural phenomena, and abstract ideas. So 101, when they're actually, examiners are looking at your application, these are the things that they will be looking to see. Are you trying to patent things that you should not? If so, then you don't get a patent, which is laws of nature, natural phenomena, and abstract ideas. And this has really gotten more fleshed out with Alice, the case Alice back in 2012, and a lot of the case law on the 101 issue has changed since then. We're not going to go into the nitty-gritties, but basically, your invention cannot be, blood, for example. Like something that exists in nature is not yours to claim. The second one is novelty, and that's covered under Section 102 of the Patent Act. And this is basically saying that your thing is new. So if I was to look at a similar product, so say you came up with a bicycle, because that's the example we're going to talk about later with respect to invalidity. If I look at your bicycle and your bicycle includes everything that was previously disclosed, there's nothing new about it. Like say, all you have is like wheels, a handle, a seat, nothing extra, no patent for you. If I can look at one other thing that previously existed, and when I say one other thing, it can mean a prior product, it can mean a publication. So someone wrote a research paper on the same thing and it disclosed everything that you're trying to claim, then it's not patentable. The third thing is what is called non-obviousness. Non-obviousness is really looking at it from a person skilled in the art. So if I was a person skilled in the art looking at, say, 3 different bicycles, and maybe bicycle A didn't have all the features of what you're trying to claim now, but bicycle B had some of it, but not again completely. Say A, B, C, bicycle A, bicycle B, bicycle C. And if I could look at all those three bicycles together and come up with the one now you've come up with, features from A, features from B, features from C, and it works the same way, and that's what I expected it to look like, then again, you don't have a patent there. So obviousness really allows for the ability to combine different references, different prior art, everything that's previously existed. If we can come up with it as a person skilled in the art by looking at these things, and it's obvious, obvious is a hard term to actually fight, but yes, that's what examiners would be looking at. And then the fourth one is 112, which looks at your disclosure, which we talked about previously. So when we're looking at 112, when the patent examiners are looking at 112, they're looking to see what you're trying to claim. Can I look at the description and actually see what you've disclosed is actually there? Like if I look at the description, can I make that thing, which is what we talked about previously? Do I have enough information to actually say what you're disclosing is actually what you're claiming? Next slide. So if you meet all these requirements, then you'll eventually get your patent. And that's what patent prosecution is. Negotiation with the patent office, that going back and forth, making sure all these requirements, stringent requirements are met to be able to give you your patent. And then you got your patent, now what do you do? So that's what patent enforcement actually means. And like we talked about earlier, patent litigation in the US, you can either go to the federal courts or you can go to the ITC. So federal courts is just generally what people expect, which is, hey, so-and-so is infringing my patent. This is all the proof I have, blah, blah, blah. You go file your claim. If you win, what you get is money damages. So for using your patent without your permission, you get money from the federal court if you win on infringement. The other thing you can do is go to the ITC, and ITC is really special in terms of what it can do. You don't get money damages, but you can block your other products from coming into the US. That's the remedy that you get. But with the ITC, you only have this avenue if an industry already exists that provides the same thing. So it's a little bit counterintuitive in terms of protection, because if for example, if it was just one novel drug and it was all coming from China and nobody else in the US could make it or had it or access to it, the US government is not going to shut down importing that one product because there is no suitable replacement for it in the US market. That's essentially what that means. It's very fast and very compressed, unlike infringement suits, which can take 3-4 years. Next slide, please.
Before we get at the next slide, I wanted to address one question from Michael Roble. He said, in the U.S., now injunctions are rarely granted, and this is reflected in Halima's prior slide. Is it our patents really a right to exclude? In theory, they are right to exclude because in theory, injunctions are still available in district courts. It's that after the case of eBay versus Merck Exchange in 2006, 20 years ago, that the Supreme Court really made it extraordinarily difficult to get an injunction in a patent case. So theoretically, yes, it is a right to exclude, but practically speaking, as Halima had mentioned, it is virtually impossible to get an injunction. So continue. Sorry about that.
No problem. So we'll go through slides. I've been told my time is up. But we talked about federal court litigation. When you file on a patent, when you're doing a patent infringement case, there's generally two theories: direct infringement versus indirect infringement. Direct infringement means I am actually using the product and I am doing all the steps. Like my product actually has all the components. Indirect means there's actually a product and you are telling someone else to use it in a manner that infringes. So for example, a medical drug. I hate to use that example, but so your drug is used for, saying, treating condition A, but your invention is for that drug to treat condition B. If now medical practitioners prescribe medication for using that same drug for treating disease B, then they are being told to infringe by the person who made the drug to go use it in that particular way. So the direct infringer in this case would be the doctor who's actually doing the prescribing for treating that particular method. The indirect infringer would be the person making the drug and selling it for the purpose of treating the disease that your invention was meant to cover. So direct, indirect. Next slide, please. So you file a patent lawsuit. There's various avenues in which accused infringer can defend against themselves. This is what we do on a daily basis in terms of patent litigation, what we come across. These are just two of the avenues. The first one is we don't infringe, which is a non-infringement, and two, the patent is invalid. So going back to, next slide, please. Going back to getting your patent, we already talked about the invalidity piece, and we'll touch on it again, but infringement just generally means that your thing doesn't practice all the steps, or it doesn't include all the components. So if you could go to the next slide, and I'll show you a quick example that kind of features that. But say what we talked about earlier was the claims or the boundaries of your invention, and that's what we look at when we're in a litigation case. So invention, the bicycle has two wheels, a seat, a frame. That's claim one. The accused example here, you can see the seat, you can see the two wheels, and you can see the frame that's connecting everything together. So basically in a patent infringement case, that's what you're doing. You're always taking the product or the thing that you think practices your invention, and you're matching it against your patent claims, which is the claims are your invention. If the thing has all of the things listed in the claim, A, B, C, D, then you got infringement. So for non-infringement, what the other side can do or needs to do is basically say we're missing at least one. Just one is all they need. If there is no frame connecting it, then there's no infringement. If there's no seat, there's no infringement. So they only need to prove there's one element from that one claim that they don't have, they don't practice, etc., to be able to defeat a patent infringement case. And then the next thing, next slide, please, is the invalidity base. So as the patent office was doing the same check, looking at 101, 102, 103, 112, an accused infringer in litigation basically can assert the same thing now and might do with a different combination of prior art or prior products, and basically say, hey, if the examiner had seen these during when the patent was going through the process, they would have never issued it. And that's exactly like what this means. So it's essentially the same thing. The examiner would be doing the same thing, trying to get you your patent, and accused infringer will be going back and saying, hey, they didn't really do a good job because if they had this combination, or they did not really look at 101 because your patent is ABCD, it was a natural abstract idea, etc., etc. So they're allowed to make the same arguments even though your patent has already issued. Next slide, please.
Hi, everyone. Thanks, Halima. We're going to quickly discuss two other types of IP protections, namely copyrights and trade secrets. So not every innovation that you create is patentable. And even if it is, there are often multiple other types of IP protections that different aspects of a commercialized product might include. For example, for a pharmaceutical product, the drug compound itself would be patented, but once it's brought to market, the brand name and logo are trademarked, the marketing materials and website might be copyrighted, and undisclosed formulas and manufacturing processes might be protected by trade secrets. So it's important to think about the different ways that your IP for your inventions can be protected. Turning now to copyrights. Copyrights offer an additional avenue of federal protection for your IP that may not qualify as a technical invention that could be eligible for patent protection. So copyright protection exists for artistic, literary, and intellectually created works, such as novels, music, and creations in digital format, including software code, such as source code, object code, and the structure, sequence, and organization of software code as well. Can we go to the next slide, please? So copyright protection is authorized by both the Constitution and the federal statute under the Copyright Act, and it covers original works of authorship fixed in any tangible medium of expression. As I mentioned before, this can often include software code. Can we go to the next slide, please? As you can see from this slide, copyrights also differ from patents in that they have different requirements and mechanisms and pathways for enforcement. Next slide, please.
And we're going to cover very quickly trade secret law and some sort of pointers, overall about different types of IP. So trade secrets are it's what it is. It's a secret. It's something that is not known. It is something that is not generally known. It has value to those who don't have that information, and you have to keep it secret. So, for example, a trade secret might be the special formula for Coca-Cola, okay, or what are the Colonel's special recipe for his chicken. Those are some things that are considered trade secrets. Trade secrets wouldn't be, for example, let's say my recipe for chocolate chip cookies. If I've given that recipe out, I might think it's mine recipe, but since I've given it out to my family or friends and so forth, it's not really a trade secret because I haven't taken the steps to maintain its secrecy. So there are many laws and regulations that govern trade secrets, and there are both federal laws and state laws that protect them. So, but usually, as Halima mentioned, there's two paths. You either go the path of patenting, where you get patent protection, but you have to disclose everything to the public, okay, and you get a limited time frame of your protection, or you go the trade secret route, where you can keep everything secret and you get unlimited, exclusivity on that, but you can't disclose that to anyone. And the trade secret rights are only as coextensive with the time frame that you maintain the secrecy. So next slide, please. Okay. So as we mentioned here, trade secrets, you have to maintain secrecy. Patents, you have full public disclosure. Trade secrets, they can last indefinitely so long as you keep it secret. But patents, you have a fixed term, 20 years. Trade secrets, you have typically narrower protection. Okay, it's typically very specific to that recipe or that particular design, or that very, very specific list of information. But in patents, depending on how the patent is claimed, you can claim broad rights to cover many different types of permutations of that invention, or you can claim narrow rights. So there's a lot more flexibility in patents, whereas trade secrets have to be very specific. It has to be, that particular recipe that I write in on this page for Coca-Cola, and it's stored in a vault. So something like that. Next slide, please. So let's go over a few pointers, and then we'll open the floor up to some questions. First, one costly mistake is not filing the patent application before you disclose the invention. Okay, this is fatal now. So in most jurisdictions other than the US, so for example, if you have your invention and you disclose it to the public, in the US, you have a 1-year grace period to get that patent application on file. But in other countries, that's not going to apply. And so therefore, you've kind of given up you've publicly disclosed your invention, and you've given up any rights to it. This happens very, very often when you're presenting materials, let's say at a conference, or publishing it in a journal, or submitting it, not even publishing, but submitting it to a journal. You're disclosing it to the public in that sense. So you have to be very, very careful about disclosure of your invention in these public arenas, even if they don't get published. But so long as you've taken the effort to disclose it, that can be invalidating. Okay. Another issue here is filing too early without technical depth. Okay, that is, let's say in my example, I had my recipe for what I thought was a recipe for my chocolate chip cookie, but I didn't put all I didn't disclose all of the steps that are necessary in order to mix and the temperatures I needed to cook the cookie and what special spices I should have put in it. If I didn't provide enough support how to make and use the invention in my specification in the application, well then that may be invalidating, and you may have to either abandon that application, or you may have to figure out some way of supplementing it with some additional subject matter, but that may shift your priority date. That is the date that you're entitled to for your filing. Okay. Now, the other issue there is that you could wait too long. And if you wait too long, more and more competitors can come to the marketplace. There could be other competitors. There could be Nabisco and Keebler and other companies that could come up with different inventions, different types of cookie recipes that might anticipate or render obvious my recipe. So you want to get that. That's why that critical date, that filing date, is so important, because it's like putting your flag, in the ground, staking out your priority over others. So sometimes there are cases that have come down to days, if not hours, of who has priority. So very, very important to do. Next slide. Okay. Other issues that are costly mistakes in handling patents is not disclosing the prior art. One of the issues in a patent is that when you submit a patent for grant, for examination grant to the patent office, you have a duty of disclosure, because you don't have your competitors out there negotiating. So they put a special duty, a higher duty upon the applicant to disclose everything that is known to the examiner. So, for example, in my cookie example, I need to disclose, well, there are Chips Ahoy's cookies out there. There are Mrs. Fields cookies out there. There are, Toll House cookies out there. I need to those are all different types of cookies, chocolate cookies I'm aware of. I need to disclose that to the examiner to say, these are all of the other prior art cookies that are out there, but here's why mine is different. Okay. So you have to make that disclosure. And because the examiner, you can't depend on the examiner on knowing everything about cookies. Okay, you have to provide that disclosure. Another costly mistake is this: if you go back, one thing is not attributing all the inventors. Okay, this can also be a problem here, or the inventorship or the ownership. You have to make sure that the inventors are all named. And this is a peculiarity of U.S. patent law, and that you have to make sure that, let's say, oh, this is really I invented this along with my my aunt, but I'm the only one filing it. Like, no, I need to name my aunt, who was a co-inventor who taught me. Okay, maybe she came up with the concept of adding boiling water to the flour ahead of time instead of just cold water. You need to have everyone who contributed to that conception of the claimed invention. Okay, let's go to the next one. The next slide, please. Okay. So other things, costly mistakes, you got to think about global protection. The U.S. patent is only enforceable within the jurisdiction of the United States. If you have to go out, if your products are made outside of the United States, or they're sold outside, or they're used outside the United States, you really need to think about global protection going to other jurisdictions, the European Union, China, Japan, Brazil, other places that might be big markets for you. You have to figure out, it's very strategic to figure out where you pursue those, and to touch on that prior question about PCT applications, patent cooperation treaty applications. That's where that comes in. Use the PCT strategically in order to figure out, okay, my big markets are the U.S., China, and Australia. Okay, what are the pros and cons? What's the cost of getting the protections in those markets? Okay. Another factor here is you've got to register your copyright, and it's got to be the version that you're going to enforce. I have lived through this one in litigation and lost, okay, because the client did not register the copyright in the Library of Congress properly, didn't file the correct version. Okay, you want to make sure you're filing your copyrights in all for every version of software you come up with. You're putting that into the Copyright Office, and there's forms. It's actually not that difficult to do, but you've got to be disciplined in doing that. You just can't say, well, it's all the same. I'm just putting in this one version, and then I'll be covered. So no, you've got to be very diligent about putting every version there. Next slide, please. Okay, so we have about 8 minutes left. And so I'd like to open the floor up to any questions you may have. I tried to integrate a few of the questions that were asked during our presentation during the course of our discussion, like the ones from Michael on injunctions, and the other one, the really thoughtful one about PCT applications. But we're happy to take any other questions, put in the webinar chat, or or elsewhere, or note that otherwise. But the webinar chat's a good one that you can type your messages in there.
Yeah, so there's a Q&A
Yeah.
a little bit to the right of the webinar chart, and
Yep.
there are questions there. I don't know if you can see
Oh, here
them.
it is. I see it. I see it too.
One
I've
of
got
the
'em here.
questions, I'll read it out, Alfonso, and you can take a
Okay.
pass at answering.
Okay.
Are the patent claims the description of figures, or are they exclusive from one another? That is there always claims section in a patent?
Okay, that's a good question. So that's one thing. The figures and your descriptions, okay, those are different than the claims. There's a statement. There's a saying that your specification, your disclosure teaches you how to make and use the invention. Your patents claim the invention. They actually set out the metes and bounds of the invention. So they're different. They're really different. They have a different purpose, and they're typically drafted very, very differently. So, for example, in my cookie example, I give all these charts and these recipes on how to make the invention, and make the cookie. But my claims are directed to the essential elements of my cookie. And let's say the essential element of my cookie is that I have to add, as I mentioned, boiling water to the flour at a specific step. Okay, if that's my invention, I have to make sure that's specifically put into the claim. Okay.
One other question is, if the invention involves a formula, would you recommend both patent and trade secrets?
It's difficult to do because in the patent, you have to disclose everything. You have to disclose, in addition to all how to make and use the invention, you have to disclose the best way to make and use your invention. Whereas a trade secret, you typically want to keep secret the best way to make the invention, because that gives you the competitive advantage. So they tend to be divergent, mutually exclusive. You either go the route of patent or you go the route of trade secret. So, another question?
There's a question about AI.
Yes.
Let's see. Could you comment on the recent ruling related to AI innovations and patentability versus copyright?
Halima, do you want to touch on that, since you actually addressed some of that AI aspect during your presentation?
Comment on the recent ruling related to AI innovations and patentability versus copyright. So we talked about inventorship exactly. I think comment is rather broad, not to sound like a lawyer, but generally, the one thing I would say with AI, it's evolving. One thing we do know for sure is you can't name AI as inventor. In terms of patenting AI technology, depending on how it is, the inventions, those are progressing with respect to 101 in terms of guidance from the USPTO and inventions relating to AI generally, not necessarily like AI directed inventions, if that makes sense. So if you're trying to protect your AI creation, those patents do exist, and the guidance on that through the patent office is evolving. With respect to copyright, I'm not particularly sure, but we can circle back on that one unless Kathleen or Alfonso have some thoughts on it.
Yeah, just very quickly, go ahead, Kathleen.
No, you go ahead.
Okay. Yeah, right now I don't think that because copyrights have to identify an author, and patents have to identify a inventor, and that inventor has to be a someone who conceives of the invention, and then and in the copyright side, the author has to be the one who creates a work and fixes it in a tangible medium. The so far the policy is that those acts of conception and creation are only done by humans, not by AI. So um, uh, that's typically how I think the agencies and probably the courts are going to be moving in that direction, because it's going to be later on, if you're going to enforce and you're trying to prove this up, it's going to be very difficult to go and take a deposition and or have the AI explain how it conceived of anything or it created anything. So, all right, we have probably time for one more question. So which one would you like to select, Ala? Oh, I think you're muted, Ala.
Sorry. So first of all, I just posted a link to register for the March 5th session on trademarks, on trade secrets and trademarks. And here's a question about a trademark. Would you recommend filing for the trademark prior to the patent? And if a patent is granted, should the inventor patent in their name or in the name of the business they will license to?
Okay, that's a good question, because they overlap sometimes. But really, the trademark in terms of the that is sort of the likeness or the identity of the business. You're going to probably need to do that. You're probably going to have that identified earlier than all the technical aspects of your patent. So in most cases, your trademark probably would be filed first. But it's going to be very fact specific. And that's something that we probably need to discuss, offline, in a confidential way. But again, it depends. A lot of times, let's say in my cookie example, let's say I come up with the cookie first, but I haven't come up with my business. So I'm going to patent it first before I come up with Alfonso's cookies. As opposed to a different circumstance. So very fact specific, and we would encourage you to go and speak with counsel, speak with those people over at the Tech Transfer and at Tech Ventures over at University of Maryland, and then they can connect you with the right people to get that done.
Thank you so much. I think we are at time. One last question. There was a question on how to get in touch with you.
Okay, yes. And probably afterwards we'll put up is there a way, Ala, to put our email addresses up? Yes. And we can connect that way. We're very, yeah. Or if you don't get that immediately, if you just go to Cahill, CAHILL.com, we're available on the directory there. We're happy to help.
Right. Anybody who wants to, you can also shoot me an email and I will forward it to Alfonso or Halima and Kathleen, and you can get in touch that way. But here is the website of the law firm. So thank you so much, Alfonso, Halima, and Kathleen. This has been really interesting and great, very informative presentation. Thank you so much for your time, and I look forward to the next session on March 5th. I posted a link for everybody to sign up to attend that session, and this session will also be posted at a later date to our Startup PMD YouTube channel. So thank you so much.
Thank you very much.
Thanks, everyone.
Thanks for everyone for joining.
Thank you.
Thank you for everybody's great questions.
Yes. Bye-bye.